Welcome to Tommy Talk. I'm civil rights attorney Tommy Strelka, and the second most common question that I'm asked is, should I resign from employment or should I let my employer fire me? Now, that's a good question. Imagine this nightmare. A meeting suddenly, mysteriously pops up on your calendar. You all of a sudden have a meeting this Friday at 11:15 a.m. with your supervisor. You show up to the meeting. You see your boss, hi. And then you see Elizabeth from Human Resources. Hey, Deborah. Hi, Elizabeth. Now, in a meeting like this, you may be presented with the option of being fired by your employer or resigning from employment. And that's the question. 1. Do I let them pin a target to me and drag me in front of a firing squad so they can all take their turns firing away? Or do I take the revolver from Colonel Mustard and Human Resources and do the dirty deed myself? Now, in this nightmare meeting, here are some things that you might hear. This wasn't my decision. It was a group decision. It was out of my hands. We can't treat you differently than anyone else. Given your work performance here, we've consulted. We have enough to terminate you for cause. If you resign, we will not contest your unemployment benefits. So what do? Well, about 95% of the time, my advice is not what people normally think. My advice is to resign. But why? Well, there are 2 considerations. Number 1, unemployment benefits. Almost all states require that if you resign from employment, which is one of the options, that in order to be able to claim unemployment benefits, you have to show some sort of good cause for why you resigned. And let me tell you, the choice you got in that meeting, it ain't it. That's not good cause. Well, Tommy, the reason I had that meeting was because the whole thing was age discrimination. I was discriminated against or retaliated against on the basis of my age, and that's illegal under federal and a lot of state laws. So that has to be good cause, right? That has to be good cause. I have had many scenarios in my practice arguing cases for unemployment benefits in front of state agencies and unemployment entities. Whenever I have argued that the good cause for resigning was actually found in another law, like, race discrimination laws or gender discrimination laws, pregnancy discrimination laws, age discrimination laws, and so on and so forth, the examiner for the Unemployment Bureau or agency scratches their head and they say things like, these are things I've been told. Tommy, that's gonna be above my pay grade. You're gonna need a federal judge if that's what you're gonna argue. Tommy, I tell you, I don't know much about Title VII of the Civil Rights Act. I do know that you need good cause, and you don't have an order that says that Title VII was violated, so I don't have good cause either right now. Be aware that if you choose to resign in the nightmare scenario, you're not automatically going to get unemployment benefits. And the fact that your employer might say, we won't contest, may have no bearing on this whatsoever. It might be easier to get a job after you've been terminated if you resign, and that's one of the leading considerations. Consideration number 2, do you have a case? Now, that's a good question. If you have a case or a claim, this means that because of this decision, having to resign or be terminated, it's wrongful or unlawful, and you could therefore point to it and proceed either to a court or to some sort of agency to make a claim against your employer for what happened. As long as you're not asked to sign a waiver or release in this decision that we're talking about, the law and the courts understand that there's a difference between a voluntary resignation and Elizabeth from Human Resources dragging you into an alleyway and putting a gun to your head. That resignation may not necessarily be voluntary. If you have questions related to whether the factual scenario of your case fit the law, you will need to consult with a licensed attorney in your state.